All right. Thank you so much for tuning into our second professional practice event of the semester. Hello and welcome to the professional practice series. My name is Alonzo Pantoja. I use he, they pronouns, and I'm going to start out with a visual description of myself in case we have anyone with low vision participating tonight. I am a brown man with glasses and dark hair sitting in a home studio space wearing a red plaid checkered shirt. And before I introduce our speaker and begin this event, I want to respectfully acknowledge that the land we are occupying in Minneapolis is unceded territory, the ancestral homelands of the Dakota and Anishinaabe peoples. Gathering here, we pay our respects to the elders, both past and present. We acknowledge the grave harm that colonialism brought to these lands, in particular the erasure of both Indigenous and African identities, not only under slavery, but the racist laws that have segregated all people. We honor those who have lived and do live now at these intersections of identity and experience. And if you'd like to learn more about land acknowledgements, please screenshot this screen here. I'll pause for about 10 seconds. Great. This event is sponsored by the MCAD MFA program, which is a community of makers, thinkers, researchers, and creative professionals working in a mentor-based interdisciplinary environment. And again, if you'd like to learn more, feel free to visit the website on the screen, mcad-mfa.com. Just a few notes, your audio and video will be muted for this webinar. If you experience any technical difficulties, please email us at av_support@mcad.edu. Please feel free to leave questions in the chat and we will select from the submissions after our speaker has presented. And a recording of this will be available made to students after the event. I want to give a few thank yous to our support staff, Kylie Van Note and Nikki Motorcallum, and of course our AV support for tonight's event. Do a quick shout out to our next professional practice event, Project Management Careers, which will happen October 5th, same time, 6 to 7 p.m. Central Time over Zoom. Similar format, you will need to register in advance. And so for tonight, our event is Contracts and Intellectual Property. And now I'll go ahead and introduce our speaker. Ruth helps clients protect their most valuable assets, their ideas, creations, providing advice and guidance on matters that touch on intellectual property rights, such as trademarks, copyrights, patents, and trade secrets, including representing clients in their registration, licensing, and resolving disputes about such rights. And now I will turn it over to Ruth and hear what she has to share, followed by a Q&A.
Hello, everyone. Let me see if I can get my screen up here. There we go. So hello, everyone. Thanks for joining this evening. I wish I was doing this in person, but it's nice to do it this way. For those of you who don't have access to video or are visually impaired, I'll do a little bit of explanation about myself. I am a white woman in her 60s with green hair. I'm wearing blue framed glasses. I'm sitting in my office in downtown Minneapolis, and behind me, I have some photographs of my children and my grandchildren. Like I said, I'm really happy to be here. I'm going to talk a little bit about intellectual property agreements, but along with that, I'm going to talk about just agreements in general and some of the important terms that you'll want to have in your agreements. or you'll want to make sure in your agreements. And I know some of you probably will experience writing the agreements yourself, and others will experience reviewing agreements that folks have sent you and making sure that that agreement complies with what you want. So before I get started, I do want to just say a couple of comments about agreements. I know a lot of times when people receive a draft agreement from someone and it looks very professional and slick and complete, the initial thought may be, oh, I can't really make any changes to this, it's final. But you always have the position of at least asking for modification. So if you're looking at an agreement, you don't agree with a provision of it, or you have questions about a provision of it, there's nothing to stop you from at least asking about that provision or asking if it can be modified. So we're going to talk about some of those provisions tonight, and hopefully this will give you some information, knowledge about when you see those in agreements, or when you have an agreement and you don't see them in there, to ask questions. So the first thing yes.
Sorry to interrupt. It looks like right now we're seeing your presenter's slide.
Okay. Let me see if I can switch that. Okay, because that's not. Well, my apologies for that.
If you go under display settings at the top, it may have an option for swap screens.
It does, but it's for whatever reason covered with my toolbar.
Okay.
So,
So what we'll have you do is stop sharing the Zoom,
okay.
or click stop sharing on Zoom quick.
Yeah.
And go ahead and click the share screen again and select the full screen side of the projection, your desktop that has the full screen on it, and that should share the correct one.
Okay. Is that?
It looks like it's still sharing your background or backdrop.
I am so sorry. This worked before and I don't know why.
It happens a lot with PowerPoint, grabbing the wrong one.
Okay. Is that one still showing the wrong one?
It is. Let's try grabbing the one that
Okay.
shows the notes on it, then see if I love how PowerPoint loves to.
Is that working?
That works. Yep.
Okay.
There
No,
we go.
I don't. The problem is I don't see my notes.
I think you minimize the notes one on the other screen. See if you can.
There we go. All right. So you're still seeing the full screen?
Yes, we are.
All right. Awesome. Sorry, everyone, for that. I think we're now ready to go.
Yep. And I
So,
see.
thanks, Bob. I appreciate it. I want to give you a little bit of overview about intellectual property, because I know that some folks, you know, it's hard to keep all those things straight if it's not something that you work with every day like I do. So I thought we would run through the basic intellectual property rights that folks have. So there's patents, trademarks, copyrights, the right of publicity, and trade secrets. So we'll start with patents. Probably not anything that you're going to be involved in with your agreements, unless you're an inventor and have invented an article of some kind. So patents generally cover a physical article, a device that has been made. Sometimes they cover systems. And so if you have an invention, the patent gives you the right to exclude others from using that invention. Trademarks, we all know and recognize, and here's a few that I'm sure most of us recognize. Trademarks designate the brand of something. It's the source of who provides the goods or the services or the products. So trademarks, they're like the Twitter, Chipotle, Best Buy, and Tesla are all trademarks. Their logos are considered trademarks too. So whether it's a design mark or a name, those are trademarks. A lot of people get those confused with copyrights. Totally understandable if it's not something, like I said, that you deal with every day. So a copyright is something that protects a work of art. So a novel, a mural, a sculpture, things like that are protected by copyright. And everyday things are also protected by copyright. So source code, a manual of some kind, those are all protected by copyright as well. And if you own the copyright in something, then you can prevent others from copying, using something like it, or distributing it to others or making money off of it without your permission. The right of publicity, although sometimes some folks don't technically call it an intellectual property, I think it fits in really well with these. So the right of publicity is your right to your name, your image, your likeness, your voice. You have a right of publicity. I have a right of publicity, and celebrities all have a right of publicity. You don't have to be a famous person to have this right of publicity. And this just gives you the right to control like the commercial value of your name, image, likeness, and voice. Trade secrets, probably again, not a lot that you're going to run into in your careers with, in the field of art, but trade secrets are things such as the formula for Coca-Cola or the spices that Kentucky Fried Chicken uses. So these are secrets that businesses keep, that if others were to have them, they would be able to compete with them in the same area. So this slide gives you the definition of that. And a lot of times you'll see when you enter into an employment or something that you might sign an agreement saying that you will keep the business's secrets. And that's what this is talking about, trade secrets. And in some cases, it may mean things like as customer lists or marketing ideas, things like that. So it's things that the business keeps secret that adds value to the business. So those are the general types of intellectual property that get protected in agreements. The ones you're most likely to deal with is going to be copyright. And you may run into some trademark issues as well if you have a company or a brand that you are trying to promote and protect. So these are some of the important terms in an agreement, whether it's intellectual property agreement or not, but these are all in intellectual property agreements as well. So we're going to run through a few of these this evening and hopefully provide a little bit of an explanation as to what these are, what they do, and things for you to consider when you are either reviewing another contract or drafting your own contract or working with an attorney to draft a contract, to help you understand what these terms are and how they're important in the overall agreement with the other party. So the first thing, pretty obvious, but you need to be really careful about this, is to identify the parties. So you need to make sure that everyone who's involved in the agreement is identified in the agreement. Generally, it's between two people or two businesses, but it can involve others as well if they're involved with it. One of the things to think about too is you're an individual, but you may also have your company that you've started. Maybe it's an LLC. You have to think about, who is going to be the party of the agreement. And generally in business, you'll want an LLC and you'll want the party representing you and your interests to be your LLC. If you're working as an individual, then obviously it will be you. You need to make sure that the parties are identified so that we know exactly who's entering into the business, especially if there are people with similar names or businesses with similar names. You'll want to make sure the full legal names, addresses, and things like that are indicated, so there's no question down the road who entered this agreement. You'll also need to make sure that everybody signs the agreement. Sometimes people forget about that aspect, but once you reach a final agreement, the agreement should be signed by all the parties that are named and involved. You also want to make sure that whoever is signing the agreement has authority to sign the agreement. So if it's someone signing on behalf of a corporation or an LLC, needs to be an officer or someone with authority to sign the agreement on that behalf. So those are just some things to think about when you're thinking about agreements or reviewing agreements, to make sure it covers all the parties that are involved, and that it's clear down the road, after everybody's kind of forgotten about the negotiations, you can go back to the document, and this will have documented everything and everybody that was involved. The next thing to think about is, how long is this agreement going to be for? That's generally referred to as the term of the agreement. Is it for 6 months? Is it for a year? Is it for a specific project? Is it an ongoing agreement? So that's something to think about, something that should be included in the provisions of the agreement, and something you should make sure that you understand if you're reviewing an agreement that has a term provision in it. Along with that, because you're talking about the term of an agreement, you'll want to think about, well, what if we want to end that agreement early? Or if it doesn't have a set term, how do we end the agreement? So that should be set out too. You shouldn't make the assumption you're going to enter into this agreement, you'll do the project, and then that means the agreement is over. It should be more definite in the agreement exactly when the agreement starts and when it stops. It can be for a period of time, like I said, a year, 6 months. It can be, when project A is done. Some agreements are automatically renewed if it's an ongoing relationship and you're doing ongoing projects. Those are things to think about. You can always enter into another agreement if you want to do one agreement at a time, even if you think you'll have other projects. Sometimes it's good to have a separate agreement for each project. So again, some questions to ask yourself, some things to think about when thinking about how long is this agreement for, and what if we have to end it early, or how do we end it once we're done with the project? The term also has something, or the termination is also related to what if for some reason you have to extend the term of the agreement. And so generally there should be a provision in there about having to extend a deadline if something were to occur. The other thing that you want to be really careful about is defining, what is this agreement about? So if this is about a particular project, then that project, the scope of that project should be clearly defined in the agreement. And it should be defined in such a way that, say, someone who's not involved with the project could read the agreement and understand what it is. So even though maybe both parties understand when you're talking about project A, later on down the road, someone may not know what project A is. So a good way to do that is to either describe project A in the agreement. For example, design and complete a mural on the corner of 8th Street and Nicollet, or something like that, right? Be very specific with the description. You can also, if it's a visual project, attach drawings of the project as an example or as an exhibit to the agreement. The most important thing is to make sure that everyone's on the same page as to what is this agreement about? What is the exact project? Because what you don't want to do is have down the road in the agreement or in the project, have a misunderstanding and understanding about what the scope of the agreement is, or what the scope of the project is. And you can't go back to the agreement and say, well, this is what we agreed to, if it's not clearly laid out in the agreement. And as I, provide here in this slide, if you have an exhibit, you can show the exact work that's being worked on. If you have a design sketched up, you can include names, dates of when it was created, and things like that, so that everybody's really clear about what the project is about. You'll also want to describe each party's obligations in the agreement. And while it may seem like, you're worried about making sure your obligations are correct and what you're agreeing to, if you're demanding some obligations from the other side, that should be in there as well. For example, should they cooperate with you? And if they're going to cooperate, is there a time frame? So for example, you send them a rough draft, you should have in the agreement that they have to respond to that within a certain amount of time. There are provisions too that say the parties will agree to cooperate. Those types of provisions not only are helpful later on, but it just reminds everybody at the time that you're doing the negotiations that cooperation is going to be required for this project to get complete. If you do have the parties' obligations and say both are obligated to participate in the project, you should also clearly say like who has the last word. So who gets to approve the final product before, it gets put up on the wall or mounted in the frame. So those are the types of things you need to make sure that it's really clear who makes that final decision. The next thing, and really critically important for you as someone who's going to be providing the product of your skills, is who owns the project after it's done. Who's going to be the owner of whatever you're creating? And this is probably one of the most key aspects, especially for people who are contributing their skills in a work of art. You want to clearly define who owns whatever is being created. And when it comes to artwork, there's two different levels of ownership. So one is, say, for example, we're talking about a sculpture, and it's a sculpture of an apple. So you've talked with the person that you have this agreement with, they've told you what they want, you create the apple, the sculpture's finished, that's the project. The other side, the buyer gets the apple. Now the question is, who owns what? So it seems pretty reasonable that the person who paid for the apple owns the apple. But that sculpture exists not just in and of itself, but it has a copyright attached to it. And that copyright is owned by the artist, the author, the person who created it, for the most part. And we'll talk about an exception here in a little bit. But the question then becomes, does the buyer get to take that apple and make other apples? Or can they take that apple and change it up a little bit and make other copies and sell that to other folks? Or do they just own the sculpture? And then the artist can go and do that sculpture for someone else. They can make changes to it. So those are the two levels of ownership. Somebody owns the actual object, but the artist retains the right and the copyright. Now, that copyright can be sold to the buyer as well. It can be part of the negotiation. And if that owner then purchases the object, they may want to also own the copyright in the object. And then you would assign the copyright to the buyer. But that needs to be worked out in the agreement. And it should be clearly stated in the agreement who owns the final project, the final product, and who owns the copyright in that final product, assuming it's a work of art. But then we come up to a work made for hire. And a work made for hire is legal jargon, right? It's actually a legal phrase that has a legal meaning. It is not what you might think it means. So it doesn't just mean someone hired you to do a work. Even though it may sound that way, that's not what it means. The law has a specific definition for this. So a work made for hire means either a work that an employee did as part of their job for their employer, or it's a work that an independent contractor has done at the behest of someone else, with two important caveats. And that is, the work by the independent contractor must have been done under a written contract, where in that written contract, both parties agree it is a work made for hire. It can't just be assumed. It must expressly say that in the agreement. And the work must fit into one of these categories that is listed in the law, in the statute. So it has to be either a contribution to a collective work, part of a motion picture or audiovisual work, a translation, a supplementary work such as a preview or something like that, a forward, a compilation of works, an instructional text, a test or an answer key for a test, or an atlas. So I don't know how this list was created. It was created years and years ago, but when they wrote the law, these were seen as specific types of work where it is a work made for hire. And the most important thing is for a work made for hire, if it falls into either one of these categories, an employee doing the work under their job, or an independent contractor that meets this criteria, once the work is completed, the work will belong to either the employer or the person who hired the independent contractor. So this is a little bit different than when it's not a work made for hire, the work automatically is owned by the author. But in these instances, a work under a work made for hire, the work is owned by the person who commissioned it or the employer. And that's really important to distinction, because if the employer automatically owns the work, there's no reason for an assignment. If the purchaser who purchases this and buys it from an independent contractor already owns the work, there's no reason for an assignment, and they have certain rights as the author and owner of that. So it's a little bit confusing, but that's really important to understand when you're entering into an agreement, especially one that uses this phrase, a work made for hire. You'll need to really want to understand that before you sign the agreement. Now, another thing you can do with artwork or a project is to license it to someone else. And that means they don't own it, but they get a license to use it, display it, distribute it. But the ownership is retained by the owner or the author. So the things to think about if you're going to license a work for someone to use, say someone wants to put a photograph that you took up on their website, but it's really limited use and you have other things you want to use that photograph for, you may license its use to this person who wants it on their website or company that wants it on its website, but that leaves it free for you to use for other instances or other circumstances. So that's the first thing. Is the license exclusive? And exclusive means that only the person who's receiving the license gets to use it. And that's it. That includes against the author. So if you give someone an exclusive license, only they can use it, you can't use it, and you can't let anyone else use it. So that's something to consider and think about in your negotiations. If you do a non-exclusive license, that means the person you're licensing it to or the business you're licensing it to may use it, but you can also license it to others, or you can use it yourself. Again, things to think about when you're negotiating price and things like that. There's also not only who gets to use it, but when someone can get to use it and under what circumstances. So to go back to the website, if you're licensing that photograph to be used on someone's website, then in the agreement, you would want to say the license is for use solely on the website. So that means they can't take that photograph and put it on coffee mugs and sell the coffee mugs, right? You want to limit how they can use it. Or you can tell them you can use it on your website and you can use it for anything that you want. So those are ways to license it, but you can divide up who gets to use the photograph. You get to decide how they can use it, and you can decide whether or not someone else gets to use it. When you're allowing someone else to use your artwork, you'll want to think about, do you want to demand that they put a copyright notice on it, which is always good to do because it gives notice to other people that someone owns it, so they don't just go and download it from the website or cut and paste it off a website and start using it. And if that's the case, then you need to have that in the agreement that the person who is licensing the photograph has to always include a copyright notice when they use the photograph. Now, like we talked about before about who the owner is, if you would prefer just to outright sell the photograph, then you would assign the rights in that photograph and you wouldn't license it. And then all the ownership goes to the person who purchases it, and you as the author would not retain any rights. So that's kind of the difference on how you can approach that. Probably one of the most important things too is payment. What are you going to get paid? How are you going to get paid? Is it going to be a lump sum fee? Do you get paid beforehand to cover the materials? Again, all important things to consider, and important things to also make sure are set out in the agreement. Because again, you don't want to agree to, I'm going to create this work of art for you, and this is all that's going to happen, and this is how much I'm going to get paid. And then weeks into it, you're asking them, oh, I need reimbursement for materials. And they come back and say, well, that's not what we agreed to. So this should all be set out in an agreement, so everybody's all on the same page, and so that you understand what your obligations are and the other side understands what their obligations are. And there's different ways to do this. You can ask for how you want to be paid. I think from what I've seen, Venmo is a way to do it, Google Pay. You can specify that in the agreement. You can ask for a check, which I don't think many people use these days, but it's, obviously still legal tender. You can still ask for that. You can ask for wire transfers. Any way that you think would be the best way for you to get paid, the easiest way for you to get paid, the best way for you to keep track of it, just include that in the agreement so that everybody knows how that's going to get done and there's no question left when it comes time for that payment to be received. And the timing of the payment, as we discussed, should also be included in that. Is, half up front, the rest done after the project is completed, payments spread out over time, or payments just to cover materials. That's all something that should be discussed and then included in the agreement. So again, everybody's on the same page. Now, indemnification is a complex issue, but it's in almost all agreements. And this indemnification means who's going to take on the risk if someone gets sued because of what happens in this agreement. So indemnification is talking about when a party outside of the agreement sues about what is made in the agreement. So this is not talking about if the seller gets upset and wants to sue the buyer, or if the buyer is upset and wants to sue the seller. This happens if, say, for example, that photograph that you sold to someone to use on their website, another photographer said, no, that's my photograph. You can't use it, to the purchaser. That's mine. And if you use it, you're infringing my rights. And then they sue the person that purchased your photograph. Under an indemnification clause, depending on what it said in the agreement, you may have to be the one that steps in and pays for the defense of that lawsuit. So that's what indemnification means. It means one of the parties takes responsibility if an outside party sues over something that is done pursuant to the agreement. Almost all contracts will have this. You as the artist, for the most part, are going to be seen as having to take on the risk that if you have a photograph that someone else thinks is theirs, that's the risk you should take, and you should indemnify your customer from having to defend against those types of claims, because you're the one that control who owns that photograph and who has rights in the photograph. So be prepared for that when you're negotiating agreements. Understand what indemnification means, and if you have questions about it, make sure that you ask. There's all sorts of things that go along with that, like who gets to control the lawsuit, who pays for the lawsuit, and is there like a monetary amount that the person who is willing to pay for the defense is limited to. Again, all those things should be set out in the agreement. So a limitation of liability is similar to indemnification in that it talks about risk and who's going to cover the costs of things. And here, this is a way to limit what you can be sued for. So what you can say in the agreement is, I will agree to cover your costs for, if something goes wrong, but only for the amount of money that you paid me in the first place. So those are some ways to limit your liability as the one performing the services or creating the product. Again, things to negotiate, things to make sure that you understand, and things to review in an agreement or make sure are in an agreement. If you're going to be liable for something that happens in the agreement, you also probably want to have some limitations on that. You also want to make sure that whatever you're creating under this agreement is protected. And so we talked about the copyright notice earlier on, about having that in the agreement, that you make the buyer have the copyright notice whenever they use, for example, the photograph. This kind of goes along with that. Although you don't have to have a copyright registration to use a copyright notice, if you want to sue someone for infringement of your copyrighted work, you have to have a copyright registration for that work at the Copyright Office. So going back to the photograph for the website, the question will be, do you pay for that copyright registration, or will the website owner pay for that copyright registration? And some of that depends on how you're giving them the photograph. If you're selling them the photograph outright and they own all the rights in the photograph, they're likely going to be the ones that pay for and obtain the copyright registration. If you're only licensing it and you own still own the copyright, the underlying copyright, you may want to pay for that copyright registration to make sure that you protect it as best you can. Again, things to think about and things to have in the agreement. And then what happens if something happens down the road and there's a dispute over the agreement? So the photograph wasn't exactly what the client was looking for, the customer was looking for, or the artwork didn't last. It started to age. It wasn't protected well. And that was, they thought, your fault, right? The buyer thought it was your fault. So in the agreement, you can specify how you want to resolve those disputes should they come up. A lot of people like to have arbitration. They don't want to go to court. They don't want to litigate. So they have what we call an arbitration clause. And that clause basically says, if the parties have a dispute over the agreement, over the payment wasn't correct, the finished product wasn't correct, whatever that dispute may be, then the parties have to go to arbitration. And if you have an arbitration clause, you generally also want to set out some of the parameters of what that arbitration would be like. Do you have one arbitration? Do you have one arbitrator who decides? Do you have a panel of three? Where's the arbitration going to take place? What can happen during that arbitration? So there are clauses that have all those specifics set out that you can choose to use. I personally don't like arbitration. I don't think it's cheaper than litigation. I think it ties your hands sometimes because you can't appeal an arbitration decision. Once the arbitrator makes their decision, it's really, really hard to appeal that decision, to change that decision, to go to someone higher than the arbitrator to have it modified. But when in court, we have these protections set up so that if you go to court and you lose in court, you can appeal that decision to a higher court. So I also do litigation, so that may be my bias. But these are all things you want to think about. Some people also think that arbitration is cheaper, and that is not necessarily the case. I've been in arbitrations that have cost as much as a litigation would be in court. There's also the option of making in the parties' agreement that they will, before they file a lawsuit or initiate an arbitration, they will try mediation. They will agree to a mediator. They will show up in the same room with a mediator, and they will try to talk this through with a non-interested third party. And these can be used in a combination too. You can agree to mediation. Generally, you either agree to arbitration or litigation. But again, these are things to think about and make sure that they're included in the agreement. If you do want to try some of these alternatives like mediation or arbitration, because the default is going to be you can litigate it. If you do want for any of these to take place and want to put it in your agreement, you should also designate where it's going to happen. So for example, maybe this website owner is in Colorado, you're here in Minnesota. Do you really want to go to Colorado to resolve this dispute? So you may want to have in your agreement that the dispute resolution, if takes place in person, will happen in Minnesota with a Minnesota arbitrator. You can designate those things as long as the parties agree to them. A lot of times too, you can have, if there's a dispute, the other side contacts and says, you know, you've done this wrong, or you haven't done this right. You have 30 days to make it right. And if you don't make it right, then I'll initiate an arbitration or I'll sue you in court. Those are things to have in there too. That is helpful because it gives people a time frame to resolve things outside of starting something official. And then we always have what's called general and miscellaneous terms, and they're always stuck at the end of the agreement. They have this heading, miscellaneous terms or general terms, and then it's a whole list of stuff. And a lot of folks just don't even look at those. But these, even though they may be called general and miscellaneous terms, these are important terms as well. So one of the most important, just like I talked about, you want to designate where a litigation would take place or an arbitration would take place. Generally, that comes into one of the general terms or the miscellaneous terms. It's called choice of venue. And this is where a dispute would take place. Again, if you're in Minnesota and the other side is in a different state, you want to choose a state that's most convenient to you to have that dispute resolved. There's sometimes an assignment clause that says you can't assign the agreement to someone else, which means that whatever your obligations are under the agreement, you will not be able to pass those off to someone else. You can't go back to the buyer and say, look, I'm really sick. I'm not going to be able to do this photograph, but a friend of mine will. Is it okay if I ask them to step in and take my place in this agreement? If there's a non-assignment clause, you're likely going to get a no, and there's no right for you to do that. Merger just means that this clause in there, if there's a merger clause in your agreement, that agreement covers everything that the parties have agreed to about that subject. So any conversations you may have had on the phone, any emails you have exchanged, unless those same terms are in the agreement, they aren't going to be seen as terms of an agreement between the parties. Even if you expressly said in the email, I know it doesn't say in the agreement X, but I want this to be there. A merger clause says we're all agreeing when we sign this, everything's in this agreement. And anything we discussed that didn't make it to this agreement, we have not agreed on, and it's not part of our agreement. So those are all really important that you look at. Make sure you understand what they are. What you don't want to do is sign an agreement with a lot of terms you don't understand, because you may find down the road that you signed something that you were not anticipating getting involved in. So I think that's it. I know I went really fast. I know that was a lot of terms. I know a lot of legal terms, but I want to make sure that there's enough room for you to ask any questions that you might have. So ask away and I will answer.
Yeah, thank you so much, Ruth. Yeah, folks, if you have any questions, feel free to type them in the chat, and then I can read them. Or if you prefer to unmute yourself, that works as well.
Well, hopefully no questions doesn't mean that you're all sleeping, because that's
Oh, I see Sarah raised their hand, maybe.
Sarah. So do you have a question, or are you just saying hi? Because either is great.
Oh, so it looks like there's two Sarahs. There's like you have two accounts. I see that you have your hand raised in one, but that's different than your screen where we're seeing you.
And you're on mute. There are like 4 of you.
Oh.
Yeah, we noticed that earlier. Sarah, maybe try logging out and logging back into the Zoom, and then it might
Oh, sure. You want me to go over work
Oh,
for hire? I know.
There we
it's-
go. Sorry. We have it so you can unmute yourself now. That was actually disabled on our side.
Okay, but I
Right.
actually was able to read the chat. So work for hire. So a work for hire, it's a work made for hire. There's two different ways it can be a work made for hire. One is if you are employed, and this is like a W-2 employee, and your employer asks you to do something which falls into your job description. Whatever you do for that employer is owned by the employer outright. It's never owned by you, owned by the employer. They're considered the author, they're considered the copyright owner. Where it gets a little bit trickier is if you're an independent contractor and you're calling what you're doing a work made for hire. So let's go back to the photograph. You're hired to take a photograph for this person who owns a website. You go, you take the photograph. You're an independent contractor. You are not a W-2. This is not a part of your employment for that person. So for it to be a work made for hire under the law, you would have to agree to that in that agreement. And you would also need to fall into one of those categories that we listed. And a photograph for a website may not fall into that category. And so even though you both think it's a work made for hire, you call it a work made for hire. If it does not fall into those categories, it is not a work made for hire. So when you're done with the project, the agreement's over, you go your own ways. The person at the website may think they own it because everybody thought it was a work made for hire. Then they go to sue somebody because they're using what they think is their photograph. But during that lawsuit, they find out they actually never got the rights to that because it was not a work made for hire. And that means that the photographer had to assign the copyrights to the website owner for them to actually be the owner. So what I generally do in my agreements to avoid all the what ifs that happen down the road is we call it a work made for hire. And we say, you know, it's a work made for hire under the statute and therefore belongs to the buyer. However, if for some reason it's not found to be a work made for hire, then the photographer hereby assigns all right and title and copyright of the photograph to the buyer. So that covers you under both situations. And that's really, we call it belt and suspenders. It's a phrase been around forever, but that just makes sure that if everybody wants the buyer to have the ownership, then that's for sure passed on to the buyer. Hopefully that helped. Okay.
And then there's a second question, which you may be reading, Ruth, from George. So thanks for this, Ruth. A lot of great information, but also a lot to remember for a student artist / designer. Can you recommend a template that could guide folks through some of the content areas?
I can't, and I thought about providing one, but unfortunately, at least it's been my experience that templates don't always work. Because the one template may not cover everybody's situation. And so recommending a template may leave out some very important things or may include some things that aren't relevant and shouldn't be in there. So I can't really recommend a template. I think the most important thing is for you to understand the terms that are in it. I also know that we have places out there that will help with things like that. There's like volunteer lawyers for the arts. And other places like that may be able to help with things like that. You can Google and get templates. I can't really recommend any of those, but you can start with one of those and go with kind of what we talked about today and work your way through it and make sure that it makes sense to you. But I can't really point you to a template that I think would be good to use.
All right, thank you. And this next one is a lengthy one, so bear with me. I'm wondering about copyright law around music lyrics usage outside of an educational setting. Like, can I use a lyric from a song in a work that I might show at a gallery and sell? I would like to use lyrics from bands that are concerned with ecology and then label the piece quotations, listen to song by band name. For example, a sculptural painting with the lyrics "Destroy those who destroy the earth," and title the work "Listen to Blankenship" by Div.
Okay, so if I'm understanding this correctly, you're asking whether or not you can use this without being accused of copyright infringement. And generally, you can't use other people's work without their okay. You can't even use it in educational settings. I understand people think that nonprofits don't get a get out of jail free card. If you're going to use somebody else's work, you need to get permission from that person to use the work. There is, and I see, Sarah, you talk about fair use. So this is the area of fair use. Fair use is a very gray area. There's a whole lot of factors that go into it. The judge kind of looks at things, so it's kind of also factor in what the judge thinks. And so fair use is very, very gray area. There are some things that are fair use. Parody is generally seen as fair use, but it has to be parody of the work that you're copying. You can't use someone else's work as a parody of something else. So fair use is very, very limited. And if you are, have plans to copy someone else's work, I would recommend that you specifically talk to an attorney, or be prepared to potentially be contacted by the other author. Hopefully that helps. I know that's not what you wanted to hear, but.
Real quick, one of the weirdest things is that there are multiple people on this call that say Sarah Peterson, and the second Sarah Peterson who asked about fair use isn't the same as me who asked the question on behalf of a student. So I'm just curious, who is the other Sarah Peterson on this call, or at least one of them? Something strange is happening where I think multiple people are showing up as Sarah Peterson. Anyway, maybe there are a lot of Sarah Petersons. It's a common name, but sorry, I'm really confused about what's happening. If the other person who said, maybe you could say what your first name is in the chat. If you are the other Sarah Peterson who asked about fair use, I'm just curious, is your name actually Sarah Peterson? We're trying to do some back end fixing.
So I'm taking from you, Sarah, who's talking. The other Sarah Peterson that asked about Big Bird is not you.
Fascinating. I guess John Hallett asked about Big Bird. John
okay.
Hallett, you're showing up as me. That is fascinating. Oh,
So, yeah.
you know what's going on? I think what happened is I sent out a link to our students who are all signing up through my Facebook page. That's what's going on.
Interesting.
Going on. That's how there are 4 of us. Thanks for being here, everybody.
I can't even mimic you. I can't even pretend to be you, Sarah.
Nor are you, John. It's really, or the rest of us.
Well, that's super interesting, but now I know how to be incognito when I show up on one of these as someone else. So yeah, so about the Big Bird, it would be the same thing, right? You can't use a representation of Big Bird in a piece, even if it's a larger piece, even if it's a small portion of it, without getting permission from Sesame Street. So as an example of this, when films are being made and say they're filming on a well-known street that has a mural on the side of a wall, even though that mural may have nothing to do with the movie, it is just part of the background. Most movie studios, if not all, will get permission if they can find the artist and track the artist down to include that mural in the movie, even if it may just flash up for a very short period of time, because the copyright owner could come back and claim that they are making a copy, which they did, right? They filmed it, making a copy of their copyrighted work. So
Great. Thank you. We're down to the last 5 minutes. So if anyone has a final question or comment, feel free to do so now.
Could I ask another question,
Sure.
Sarah? And actually, hi, everybody. I'm gonna read something from a contract that I've personally signed recently, but that I'm like, what exactly does this mean? What happens if there's something about signing a waiver of rights pursuant to the Visual Artists' Rights Act? Can you talk about that in terms of like artistic deliverables? I've been asked to sign a waiver of rights. I will be asked to sign a waiver of rights pursuant to the Visual Arts Rights Act. Are we talking about things, have you been talking about things connected to the Visual Artists' Rights Act? Just curious what you know about the Visual Artists' Rights Act and what a waiver of rights around what I would make would mean. Thank you.
Right. So there's something that's called moral rights. And those they actually started in Europe. It's more of a European type of doctrine. But that's just like the author always has an intrinsic right to the work. And they should be able to say like their work can't be used in a way that causes their reputation to be affected. And things like that. So, and I can't remember exactly when it was passed, but the act you're speaking of, Vera, I think is how people refer to it. It really relates only to fine art. So it has to be something that is considered fine art. And I don't know that that's described really well, but fine art. And then it has to do with your right to, even if you assign the copyright to someone, there are these rights under Vera that belong just to the author and always belong to the author unless they're specifically assigned. I have not had a lot to do with this, so I don't know all the ins and outs, but I do know, for example, if it's a work of fine art and it's protected under that statute, things like destruction can't happen without the permission of the copyright owner. So those are some of the things, or it can't be used in a manner that the author would disapprove of. So say if it was used for someone's campaign that you don't like, you politically, and you think it's going to hurt your reputation, even if you had assigned the copyright, you might be able to affect the way someone can use that in the future. So most people who are purchasing a piece of artwork, they want a waiver of that so they don't run into that in the future.
Thank you so much. That's useful to know.
Yeah, sorry I can't provide more information. I just haven't looked into that issue.
Yeah, no worries.
So
yeah, thank you. I appreciate that. I think it's coming up in the context of I have an artist residency in a government agency, and that's one of the things they mentioned, or that's part of our contract. So
government agencies are notoriously very difficult to negotiate with. So
I know.
throw that out there. I have done that before, and it's very difficult. You have to be willing to walk away if you don't get what you want, and that's kind of hard to do sometimes.
Interesting. Very interesting to hear that from your perspective. Thanks again.
Yeah, absolutely. I appreciate everybody showing up tonight. And Sarah, for you doing it 4 or 5 times. So that was great. But thanks everyone for your time. I appreciate it. I'm on the website. I'm at Stinson. So if anybody has a question, feel free to reach out to me, and to the extent that I can answer it, I'm happy to do so.
Great. Yeah, thank you so much, Ruth. That was very concise and thorough. And thank you all for joining us tonight. Feel free to join us again for our next ProPrac in October 5th. All right, have a nice night.
Thanks, everybody. Bye-bye.